morning, Chairman Powell, and the rest of the Criminal Justice and Public Safety Committee. My name is Representative Brian Gallagher, and I represent Belknap District 4, which comprises the towns of Sandwicton and Tilton. I appreciate the opportunity today to present to you House Bill 1525, an act relative to the circumstances that constitute indecent exposure and lewdness. Mr. Chairman, I initially would like to acknowledge that this bill has created or caused some uneasiness with membership. However, it is my goal today to present information initiated by constituents in my district who have expressed concern on female toplessness resulting at the Guilford Town Beach, Hampton Beach, and the Weirs Beach. House Bill 1525, which I'm sure the committee has a copy in front of them, so I won't read it. I want to make some critical points. There is a specific exemption in this bill where it does not apply to the act of breastfeeding. There's been some confusion in the media, so I just want to put that up front. The most important points to focus upon in examining this bill are public place, presence of another person, reckless disregard, whether a reasonable person would be offended. That is the substance of the bill. This legislation is modeled after existing Arizona statute. The statute is law, and it has been challenged in Arizona, and the Arizona appellate courts have upheld the language in their jurisdictions. You may hear testimony here later today that New York ruled differently. New York's laws and wording are different. However, what we need to do is to pay very close attention to the proposed wording in House Bill 1525. Next, I would like to address some arguments you may also hear today. One, regarding First Amendment protection to free speech. The prohibition offends the anti-discrimination laws of RSA 354A. Both of these issues have recently been decided by the 4th District Court Division in Laconia, presided over by Judge James Carroll. I will be leaving a copy with the committee today of the court order as a result of that case. What I'd like to do, though, is to highlight a very summary. On page 4, the court finds that the demonstration on the beach in September of 2015 is not symbolic expression as protected by the First Amendment of the U.S. Constitution and by the New Hampshire Constitution. The court does not find prohibition against females appearing topless as discrimination and is not a violation of the Equal Protection Clause. On page 5 of this court ruling, the court does not find the prohibition, in this instance female toplessness, violates any constitutional protected right. Finally, also on page 5, the court finds the township, Guilford in this case, has a compelling interest which is met in maintaining the beach as a natural resource to be enjoyed by young and old, men and women, families, single persons, while pursuing a standard that allows the township to maintain their local values and mores. Now, these important issues of law have been adjudicated, so one might ask, why do we need House Bill 1525? The third important component of the suit heard in Belknap County by the defendants argued that no state statute which prohibits the public display of the female nipple or breast, RSA 645:1, indecent exposure and lewdness. The defendants were determined to be correct. The court went on to rule New Hampshire Criminal Code mandates that no conduct or admission constitutes an offense unless it is a crime or a violation under this code or under another statute. The court further went on to say that since there is no prohibition of state law which prohibits this expression, the court found that the township lacked authority for a criminal prosecution, which is neither provided for in criminal code or by statute or enabling legislation. Thus, House Bill 1525 is before you to address the important question for New Hampshire on what direction we as a state want to go moving forward on this issue. To allow public toplessness or not in public. There are moms and dads who live in New Hampshire with young children, as well as grandparents and grandchildren, who struggle with this public conduct and evolutionary challenge to family values. I submit to you these folks are entitled to the same rights to enjoy public space as others. It's a shame that some folks are more concerned with exposing their breasts in public places than they are concerned with how families and children may be impacted by being forced to experience this evolving societal behavior. Some individuals are very eager to assert their rights, but so reluctant to accept their responsibilities. A lack of respect for others, I believe, eats away at our society. I ask you, as a committee, to stand up for the freedoms of New Hampshire families and citizens to live in a public society free of forced normalizing behavior in the 21st century. By presenting this bill, the discussion is now in the open for New Hampshire to decide whether or not to promote this topless behavior in public spaces or not. This simple yet very complex question needs to be examined and answered by this committee, and your decision will determine where the public policy goes. You may have a difference of opinion from what is being presented so far. You most likely will hear that female toplessness at the beach is not a big deal. And since men can go bare-chested on a beach, why can't women? Simply answered, it is an indisputable fact that men and women are physically different. And this goes back a ways to the beginning of time. Do you not know your body is a temple? Also, if the purpose was this limited scope to only beaches, quite frankly, it may have some merit. But the larger picture shows it is not intended to be limited. This is only the beginning. Like almost all changes in society, they start small, sometimes unnoticed, and then before being recognized for what they truly are, they have grown into a trend that has become the new accepted public behavior. This is where I caution the committee to not only look at the now, but look forward to where this could lead us in the unintended consequences it may create. To help look forward, I would suggest that the committee, through your researcher, consider visiting the website breastarehealthy.wordpress.com. This website belongs to a person who is in favor of this movement. This website answers that future question very clearly. I had the opportunity in December of 2015 to meet for an hour and a half with a nice person, Miss Chelsea Covington, in the Statehouse cafeteria to discuss this bill and to try and understand her opposing viewpoint. It was a very respectful and cooperative discussion. We simply agreed to disagree. Her website shows public documentation of toplessness behavior at public locations where other citizens, including children, are present, which goes beyond the public beach locations suggested as the only places for toplessness in New Hampshire. For example, what you will find is toplessness at the Rock Creek bicycle path in Washington, D.C., in front of the U.S. Capitol building in Washington, D.C., at the National Mall, before the Smithsonian building, public space in York Beach, Maine, hiking trails in Green Mountains of Vermont, Scullykill River Biking Trail, Philadelphia, Washington Memorial Monument in Washington, D.C., Georgetown University College Campus, Prescott Park in Brooklyn, New York, playing Frisbee, St. John's River, Dover, Delaware, behind the state capitol. I think I've made the point. House Bill 1525 focuses upon the public spaces and behavior the state wants to choose to condone as being acceptable in these shared spaces. I would also suggest that the committee consider visiting the DREAD State Resource and Economic Development website on tourism and promotions. There you will find the following quote: New Hampshire enjoys 4 seasons, all of which are a dynamic backdrop to endless recreational opportunities on all our lakes, along our seacoast, and throughout the mountains. This is what markets and promotes our important New Hampshire tourism. This committee, of course, is aware of the general fund dollars that help to support so many critical services in New Hampshire. These dollars are generated from tourists both within and from outside the state who enjoy our family-friendly atmosphere described in the state website. With constant financial pressures to adequately fund critical services in New Hampshire, I submit we want to be very careful not to create unintended consequences which will cause a decrease in tourism activity, thus affecting important revenues from the New Hampshire General Fund. I want you to consider the following. If toplessness is deemed an acceptable public behavior, what would prevent it from being acceptable at these public places? Public schools on a warm September or May day. Public libraries where our seniors gather and children are there for reading hours. How about at the elementary Little League game or the soccer games? Public county fairs, they're popular venues. How about at the UNH alumni football game in the fall? Certainly many more places that we can consider public. Why not, I ask? Why not? Ladies and gentlemen, this is not about a proposed expansion of simple nudity or female toplessness at a beach like Hampton, Weirs, or Guilford Town Beach. This is about a movement to change the values of New Hampshire society. Please recognize what it is and the likely consequences if we as legislators fail to act. Mr. Chairman, I will pause to allow others to present information to you on this House bill proposal on indecent exposure and lewdness. I simply ask that after you review, after hearing testimony from others, and after careful deliberations on this difficult topic, that the Criminal Justice and Public Safety Committee recommend House Bill 1525 FN enact relative to the circumstances that constitute indecent exposure and lewdness as ought to pass to the full House for consideration in the 2016 session. I conclude with this thought. Everyone is in favor of free speech. Hardly a day passes without it being extolled. But some people's idea of it is that they are free to say what they like, but if anyone else says anything back, that's an outrage. Winston S. Churchill. Freedom is one thing, respect is another. Once again, Mr. Chairman and the full committee, thank you for the opportunity to present some remarks this morning.
Thank you. Will you give the clerk your notes and make it life a lot easier?
Absolutely, I can email too if you would like.
Any questions? Representative Martin.
Thank you, Mr. Chair, and thank you, Representative, for introducing this bill. But as I see it, society has already shot itself in the foot in this age of cosmic gender bending. How do you deal with a male identifying as a female or a female identifying as a male without opening up a whole Pandora's box of unintended consequences trying to regulate it?
Thank you, Representative Martin, for the question. I certainly wouldn't sit here today and say that I'm an expert on, an answer like that or a question like that, but I can offer you some information on how I think about it and maybe how we can address it. As I said earlier in my talk, men and women are physically different. Our politically correct thinking has obliviated discussion and it's blurred the lines of common sense. Women can have babies. Men cannot. Men have testosterone. Women have estrogen. I'm not aware of a men's group that's lobbying and protesting for male breastfeeding. Just think about our memories. Women have the enhanced ability to recall memories that have strong emotional components. Men tend to recall events using strategies that rely on restructuring of events. We're all created in the same image and likeness of God, differently to complement one another. As our society evolves and tests the limits of what gender is and what a man and a woman is, that's something that we all experience. So I don't have a clear solution to your question, Representative. I simply point out that history and tradition has shown that there's enough precedent for common sense, practicality to begin to reemerge in our society today.
Thank you.
Representative Burke.
Thank you, Mr. Chairman. On line, I think it's the first page, line 7, it starts off with exposes. Is it just the nipple that is not allowed, but in here it says breast or breast in public, her breast or breast in public? I guess I'm, wondering, I see some ladies, and of course, being a male, as you pointed out, we are different, I will definitely look, that have cleavage. Is that breast? So would they be violating this law if they had a very large cleavage that they were showing, without showing the nipple?
Thank you, Representative Burt. The clear intent of the bill is to address the situations that were a result of the demonstrations this past summer where a selective group of women chose to disrobe their entire top. It's not the intent that a person who dresses in a manner where some of their body is shown would be in violation of this law. It does go to the heart of drawing a line on what will be acceptable and what will be unacceptable in the public space. Toplessness, by its clear nature, I believe, describes that situation.
Okay, thank you, Mr. Chairman.
Representative Robertson.
Thank you, Mr. Chairman. You realize that up until the 40s, bikinis, two-piece suits were illegal. It was illegal for a lady to show her belly button. Would you go back to that?
Thank you, Representative Robinson. A little bit before my time.
Not mine.
I'm not looking to go back to that time. What I'm trying to do as a result of concerns from constituents, and I'm sure you have constituents that are concerned about other issues in your area, I'm concerned about this specific topic that's before us here in 2016, about female toplessness in the public space. That's where I'm focused.
Thank you very much. Any further questions?
Thank you, Mr. Chairman.
Representative Horning.
Thank you, Representative Falls. I guess I'm going to disagree. I'm representing Timothy Horgan from Stafford County District 6, which is towns of Durham and Madbury. It's actually near Portsmouth where Prescott Park is located. So I'm not sure whether Representative Gallagher meant that there's been a demonstration in Prescott Park in Portsmouth or perhaps Prospect Park in Brooklyn, and also the school, whether the Schoolville Park in Philadelphia, it's not the Schoolville Park, but that's a minor point. So I basically totally disagree with pretty much everything I just heard, except that men and women are different. But this bill is unnecessary because all public acts of gross lewdness are already forbidden, regardless of which body parts, if any, are exposed. The language about breasts is discriminatory because it only deals with women's breasts and nipples, as has already been pointed out. Men have breasts and nipples, and if this bill passes a law, they can show them off all they want. And that is just as well, since male toplessness is commonplace in American society, even in pretty conservative quarters. Female toplessness is much less commonplace, but I don't think that doesn't mean it should be illegal. Definitely, just because Representative Gallagher is offended by it doesn't mean that it needs to be made illegal. It harms no one. In some quarters, it is perfectly acceptable, as I think has already been admitted already. I think the language about reckless disregard for whether a reasonable person would be offended or alarmed by such an act theoretically renders the proposed law unenforceable. I think no reasonable person could ever be offended or alarmed by anything as normal and harmless as a breast or a nipple. Finally, Section 2, which is pointed out, which carves out an exemption for breastfeeding, which is a reasonable idea. The way the bill is written applies to not just to the proposed new subparagraph RSA 645(1), Roman numeral 1, parenthesis B, close parenthesis. It applies to the RSA of RSA 645(1), which includes just about anything would become legal if you work, any act would become legal if you work breastfeeding into the performance amount, including the rather extreme activity forbidden in RSA 645(1), Roman numeral 2. This bill, as the committee knows much better than I do, because they're the experts on it. We originally started with just subparagraph 1, which is just about regular indecent exposure, and then there's subparagraph 2 has been added over the years, and that type of act is just a misdemeanor, and then subparagraph 2 is a Class B felony, basically for sexual contact with sexual exposure to children, which is a much more serious crime than simply ordinary indecent exposure. Certainly, that would be the ultimate and unintended consequences of conduct covered by paragraph Roman numeral 2, something becomes legal just if you claim that there's breastfeeding involved somehow. I find that very hard to imagine. So I think this bill is discriminatory, it's unnecessary. I think the conduct, which was deplored by Reverend Gallagher, should continue to be legal. There's not that much of it. I know, for example, on the season ticket football games, under existing law, I've never seen any female toplessness at the football games. I mean, I wouldn't be particularly offended or alarmed by it. I mean, I might think it was a dumb thing to do, but I've never seen any there. Never even seen any at the New Hampshire Motor Speedway races, even though there are dumb men who are frequently calling on their female fellow fans to expose themselves. So that's, I think this is just a very bad bill. It attacks a non-existing problem. It attacks conduct which, although maybe controversial, shouldn't be illegal. So I urge the committee to find any speed into legislation.
Representative Hirsch.
Thank you, Mr. Chairman. Thank you for your testimony. Representative Gallagher, part of his testimony focused in on, the change starting small and then expanding into parks and all that stuff. And you just mentioned what we're seeing on a general basis elsewhere. In Europe, where such activity is fairly commonplace at the beaches, it has been for decades. Are you aware of any expansion of that into city parks or anything like that?
I think people in Europe, I haven't been there myself for a number of years, but I certainly have friends who visit there. People behave pretty well in Europe most of the time, just like they do in America. So I think it's, and I really, I think the toplessness on beaches, I think is not a problem in Europe. It's not very common here. It would be kind of scandalous if you did on the beaches, but I don't think it would be a problem if people started doing it on beaches here in New Hampshire. I think that's not a societal evolution that I think we offended or a lot of times it does come to pass. Certainly in Europe, people behave pretty much the same as they do here in the United States, which means most of the time pretty well.